something that's a little unpleasant and a lot of people don't like to talk about or think about, but it is a relevant topic that I want everyone to think about. As you all know, I'm not a lawyer. However, I worked as a paralegal for 10 years, and during that time I gained some very valuable knowledge. Estate planning documents are important for all adults to have, and those documents include a last will and testament, or could include a revocable trust if you choose. It's not necessary for everyone. Durable power of attorney, designation of healthcare surrogate, and a living will should you choose to have one of those as well. Not everyone likes to have those either. The first document I'm going to talk to you about is the last will and testament and revocable trust. That document is going to be the document that facilitates where your assets are going to be distributed to. Also, if you're a parent, you would appoint a guardian for your children under that document, so it's also important for parents. Difference between a will and a trust: a last will and testament would go through probate in the courts, and a revocable trust does not, so that's a benefit to having a revocable trust. Some people think it's a matter of money versus a lot of assets versus not a lot of assets. That's really not the issue. Some people choose to have trusts when they have young children. Also, the other important thing is who you appoint to administer your estate once you're gone. You can appoint either individuals, being family members or friends, or you can appoint financial institutions to serve in those capacities as your personal representative or your trustee. And also, well, obviously, you can't appoint a financial institution to raise your kids, so that would be something you'd have to strongly consider. You'd have to appoint someone that you trust. The court does take it under advisement. They are not required by law to follow your requests, but they do strongly, in the state of Florida, they do strongly take it under advisement. So you also have to consider whether you're going to have your assets distributed outright upon your death, or if you want to have it held up in trusts. You can have trusts created under your will or a revocable trust, which is a separate document. And you can decide to leave your entire estate to charity if you choose. The next document that I'm going to talk to you about is a durable power of attorney, which is, that's where you would appoint someone to handle your financial assets if you were unable to do that for yourself. It's a pretty serious document. That document is only controlling while you're alive, but it is effective as soon as you sign it. So if you were to execute it while you're still well and somebody got a hold of it, they have the ability to use that while you're still mentally competent. And then, so you want to be careful who you appoint. You have to really trust the people that you appoint under a document like that. Most times, if you're married, a husband and wife can appoint each other to serve in such a capacity. Other times, it's often a family member. But it does eliminate the necessity for guardianships and things of that matter should you get into a car accident or have a stroke or something of that nature, and you need to have somebody handle your finances for you. The third document I want to talk to you about today is a designation of healthcare surrogate. That's who you would appoint to handle your health decisions if you're unable to handle them for yourself. Again, you can choose to appoint family members or friends. Most times, again, if you're married, you would appoint your spouses first, and then or family members, your parents, brothers, sisters, people you're close to. That document, typically a financial institution would not help you out with. They will accept a power of attorney, but not as a healthcare surrogate. The final document I want to talk to you about today is your living will. That is the document that you sign that tells your family members ahead of time whether you want to be on life support or not. If you're at the end of the line, you have an end-stage condition, and there's really no hope of you coming back, which has been determined by more than one doctor. That's going to tell them that you don't want feeding tubes or respirators, and you don't want to be on life support. So it prevents your family from having to make those choices for you at the end. So if you're comfortable signing a document like that, it does take those difficult decisions out of the hands of your family members. It's just a stressful enough time when something has gone wrong with someone in your family or with anybody in your life that they wouldn't have to make that decision for you. If you go ahead and lay those things out ahead of time, then they only have to deal with the stuff that's right there in front of them. So what I wanted you to take away from this today is that estate planning documents are very important. If you plan ahead and prepare for the future, it relieves the stress from your family and also from yourself. You can hand your documents out to family members, or if you go on trips, if you go away, you can have them in a safe place so that if anything does ever happen, somebody knows where they are. And I recommend that everyone has them.